I hereby declare this meeting of the Howell Township Zoning Board to be open. Adequate notice having been given pursuant to the New Jersey Open Public Meeting Act in the following manner. First, on January 15, 2019, a copy of said notice was mailed to the Star Ledger and the Tri-Town News. Second, on January 15, 2019, a copy of said notice was hand-delivered to the clerk of the Township of Howell. Third, on January 15, 2019, said notice was posted in the office of the Zoning Board and on the bulletin board in the Howell Township Municipal Building, 4567 Route 9, Howell Township, New Jersey. In accordance with the Fire Prevention Code and your safety, please be advised that this facility is designed with 2 emergency exits, which are on your right at the front and rear of the meeting room. Furthermore, smoking is not permitted in the municipal building. Please take note that this meeting is being videotaped for possible future broadcast on Howell Township TV 77. This meeting is a judicial proceeding. Any questions or comments must be limited to the issues of what the board may legally consider in reaching a decision, and the decorum appropriate to a judicial hearing must be maintained at all times. Thank you.
Thank you, Eileen. Can we have a roll call, please?
Yes, you may. Mr. Hughes?
Here.
Mr. Mertens?
Here.
Mr. Moretti?
Here.
Mr. O'Donnell's been excused. Mr. Orozco?
Here.
Mr. Saya?
Here.
Mr. Cantor?
Here.
Mr. Laughlin?
Here.
And Chairman Nansen.
Here.
You have a quorum.
Thank you. Can we all stand for the Pledge of Allegiance, please? Pledge allegiance to the flag
of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Tropoli, mind swearing in the professionals, please.
You swear that the testimony you give this evening will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Record to reflect tonight we have Mr. Pelham, Ms. Dean, Mr. Howard, and the ADA counsel for the municipality, Chris Casource, to my right.
Thank you, sir.
Well,
Approval of minutes,
There's no minutes this evening.
vouchers,
We have no vouchers.
correspondence.
I have no correspondence.
Wow. Resolutions, case number BA 1901, Jason Property Management Company LLC. Resolution granting use variance approval for expansion of non-conforming use. Eligible voters, Hughes, Mertens, Moretti, O'Donnell, Saya, Laughlin.
I'll make a motion.
Motion by Mr. Mertens,
Second.
seconded by Mr. Hughes.
Yes, sir.
Can we have a roll call, please?
Yes, you may. Mr. Hughes?
Yes.
Mr. Mertens?
Yes.
Mr. Moretti?
Yes.
Mr. Saya?
Yes.
And Mr. Laughlin?
Thank you.
Motion carries, resolutions memorialized.
Okay, we're gonna do something, we're gonna bring our last case on the agenda, case number BA 1910, Marveri,
Mariah
Mariah.
Kororowska.
the last name,
Kororowska.
Kodorowska. Okay. Bulk variance for voluntary reconstruction of single-family dwelling on undersized lot. Application of Mariah Kodorowska as applicant owner seeking a bulk variance approval for voluntary reconstruction of 3-story single-family dwelling on an undersized lot on premises known as Block 129, 1101, 147 White Street. Expiration date December 26, 2019. Come forward, please. And you can have a seat. There's a mic right in the middle if you want.
I don't know that, wait a minute, yes, here, the proof of service and the drainage narrative.
And that little square is
That's the
is a
mic.
mic. Yes, sir.
Okay.
Okay, do you have any witnesses?
Yes, I have 2 witnesses, Mr. Chairman. Ms. Kodorowska will
testify very briefly, and our engineer, Mr. Challoner.
Okay, Mr. Tropoli, you
Swear them
want to swear the witnesses in, please?
Thank you. Folks, would you please rise, raise your right hand. Swear the testimony you give this evening be the truth, the whole truth, and nothing but the truth, so help you God. Ma'am, starting with you, may we have your name for the record?
Maria Khodorovska.
Thank you. You may have a seat, and Stuart.
Stuart Challoner.
Very well. All sworn. And Mr. Pavlik, do you have any additional exhibits that you'll be introducing tonight?
Just for the secretary's file, I have the buy-sell letters which were sent to the adjacent landowners, which would have been a Mr. Dyge and a Mr. and Mrs. Nagel. I have the green cards and the white cards, both, they were picked up. They were not returned on.
I understand. Let's mark that as A12 at this point, and then you can begin your presentation.
Thank you. You want to mark them both as the same thing? I'll put them together.
Yeah, let's do that.
A12.
Gentlemen, the application here is a simple one. It's a simple bulk variance. The lot conforms in all respects other than frontage. The applicant will testify briefly that she has made an effort to buy the lots, but even if, or sufficient property to make the lot conforming, but even if she had been successful, it would have been a futile effort because you would have taken two pieces of land from two adjacent lots and created two non-conforming lots to make this lot conforming, or in the alternative, you would have swapped out one non-conforming lot for this one, which would have served utterly no purpose. Other than that, I'll just have Ms. Khodorovska answer two questions. Maria, did you in fact send out buy-sell letters to the adjacent property owners?
Yes, I did.
And did anyone contact you offering to sell you land or to purchase your lot?
Nobody contacted me.
I have no other questions of this witness.
Professionals?
Nope.
Okay,
Okay, then we'll go, Mr. Challoner, I don't know, do you, has he testified before the board? Do you accept his qualifications, or do you want me to qualify?
we need to put them on the record, please.
Okay. Mr. Challoner, would you please apprise the board of your qualifications and what boards you've testified in front of?
Good evening. Again, my name is Stuart Challoner. I'm a licensed engineer and professional planner in the state of New Jersey. I've been in front of this board several times. I was here in front of the planning board last Thursday. I own my own business since 1995. I'm located in Toms River, New Jersey, and I testify throughout the state.
We accept your credentials.
Okay, Mr. Challoner, have you seen the board engineer's letter dated August 28th of 2019?
Yes.
Let's go through it so we can address any concerns the engineer and the board may have had through there. I guess we can, A is just general comments. Let's start with B, the variances and that we are requesting in this matter.
Yes, we're seeking a variance for the lot width. The property has a 200-foot minimum lot width requirement. It's an existing 117-foot. The property existed in this condition prior to 1970. I have a copy of the deed that had a deed of transfer in 1968 in the same configuration that it is today.
Now, we are requesting particular waivers on this lot, are we not?
That's correct.
Would you go through the waivers and explain why we are requesting the particular waiver?
The first checklist item is the waiver for the easement. We did bring a copy of the easement for JCP&L with us. We could submit that as part of our resolution compliance if the board deems this project approvable. We also seek a waiver,
Curb and sidewalk.
for curb and sidewalk. There's no curb and sidewalk in the vicinity, and the applicant's seeking to keep it in the same condition that the property's in currently. The applicant will provide the right-of-way dedication as requested. And I think that's it, right? I don't think there's anything else. And the only thing that we were interested in putting on record is the applicant is constructing a two-story dwelling with a basement. There is a confusing ordinance in Howell Township regarding basements and cellars. We just want to put on the record that the applicant's building a building that will meet all the building height requirements of Howell Township, and it's going to have a basement.
So where does the three-story come in?
It doesn't. So there's no story requirement in this zone, it's just the overall height, and the proposed dwelling complies with the height. So the only reason that they're here and couldn't just pull a permit was because of the width of the
Right.
lot,
Okay.
which, as Mr. Challoner had indicated, has been in existence prior to 1970. They've made the adequate attempt to purchase or to sell to adjacent property owners with no response. So therefore, I would categorize this as a C1 hardship variance, and that I see no negative impact to the surrounding land uses, the zone plan or zoning ordinance, and I would support the relief requested.
Are they staying, are you staying within the foundation?
No.
Existing?
No.
There's no
Such-
house there now, but the house conforms with all the bulk requirements.
Okay.
Another note about the lot, this is in the ARE 2 zone, based on 18850, it goes down to ARE 1 zoning, because the lot was in existence before 1981. There's another ordinance, chapter 18835, that actually gives a 20% reduction on even all the yard requirements. So the 200-foot required frontage is technically only 160 feet, so the lot is still short, but it's not even short as much as it seems.
Okay.
So, Stuart, just a couple quick questions. So, is your professional testimony that there's going to be no impact to adjacent properties from stormwater runoff with the proposed grading?
No, the applicant will meet the existing grades in the perimeter, and really, the big change was the house was further back, the original house. We're constructing a new house closer to the road. It's going to have a new driveway, new access out to the street, new subsurface septic disposal system going to be constructed. They'll be current in today's standards, and all the grading will be in accordance to the township standards.
And then
Okay.
you'll size the dry wells for the water quality storm. You got no issue with that?
That's correct.
Okay. And then you'll obtain any Howell Township, Monmouth County Board of Health for abandonment of any existing wells or septic systems?
We have those approvals in hand already.
Okay, that's all I have.
Jen?
No, that's it.
Matt? Any questions from the board? Seeing none? Yeah.
I make a motion for public hearing?
Motion by Mr. Moretti. Seconded by Mr. Hughes. All in favor?
Aye.
All opposed? Okay, at this time, anyone here for case number BA 1910 would like to come forward, ask questions? Seeing none, can I have a motion to close?
Motion to close?
Motion to close by Mr. Moretti,
Second.
seconded by Mr. Cantor. All in favor?
Aye.
All opposed? Okay. Any further from the professionals? Further from the board? What's the pleasure of the board?
Mr. Chairman,
Yes, sir.
this appears, in my estimation, based on the professionals that we have, a straightforward C1 hardship variance. It's pre-existing. The applicant has done all that they could in due diligence to try to obtain the lots alongside. She had no success. So therefore, I would recommend approving this application in accordance with all the engineers and planners reporting,
Okay. All testimony, correct.
all the
Okay.
testimony.
Motion by Mr. Seiya,
Second that motion?
seconded by Mr. Moretti. Can we have a vote, please?
Yes. Mr. Hughes,
Yes.
Mr. Mertens,
Yes.
Mr. Moretti,
Yes.
Mr. Orozco,
Yes.
Mr. Seiya,
Yes.
Mr. Cantor,
Yes.
Chairman Nansen.
Yes,
Motion carries.
thank you.
Thank you,
Good
gentlemen.
luck.
Thank you.
Thank you.
Is the next meeting for this board this month, or do we wait till October for the resolution?
Should be able,
September 23rd
right,
is our next meeting.
I should be able to have it ready for you.
Okay,
Do
thank
you have a
Mr.
card with
Chapel.
you, Alan? Do you have a card or an email?
Yeah, I think so.
Yeah, oh, I'll get it from our board secretary. I'll send you a draft.
Okay, next case before the board, case number BA 1903, Julian Leon. Bulk variance for disturbance in structures in farmland buffer and conservation easement. Application of Julian Leon as applicant Julian and Andrea Leon as owners seeking bulk variance relief to continue landscaping activities mowing within the 50-foot conservation easement and for an existing swing set and sprinkler system to remain within the conservation easement on premises known as Block 167, Lot 32.40, 5 Vicksburg Court. Expiration date September 30th, 2019. Eligible voters, Mertens, Moretti, O'Donnell, Saya, Cantor, and Nance. Do we have any others that have certified?
I don't have any, no.
Okay. Welcome.
Chairman, thank you.
Okay, just a brief, Mr. Tropley, if you want to go over where we're at right now.
Thank you, Mr. Chairman. When we were last here, I believe Mr. Leone had concluded his case, and I'd like to confirm that at the end of my presentation here. We also adjourned the case and carried it to tonight for further consideration by the DEP, and I believe everyone knows that the DEP has submitted a letter that was generated as a response to Mr. Howard's request. It's dated 8/23/19, and it sets forth the DEP's position with respect to the application at hand. That's Exhibit B11.
Okay.
So,
Has the applicant been provided with this?
I made,
Yes.
we made sure that everyone had it. It's entered into the record, so
Okay.
it's a matter of, it is a matter of record. So that is the new addition, if you would, for the reports from the board's perspective. Again, we have no further witnesses. The DEP indicated that they would not be presenting anyone this evening. So essentially, Mr. Chair, as I understand it, we're back to Mr. Leone for any final comments he may have or board questions of Mr. Leone. I don't believe we got into it that deeply.
No.
And that's pretty much where we're at this point, as I understand it.
Okay. Mr. Leone, I had a couple of questions for you based from the last meeting. It's kind of a timeline sort of questioning here. Whenever you purchased the house, was their irrigation system already installed at the house?
No, sir.
Okay, as far as the contractor, you hired the contractor, correct?
As was mentioned at the last meeting, we had hired a general contractor to do landscaping and create a patio in the backyard, which includes the irrigation system and the swing set. That contractor defaulted on the job at some point during the job after the irrigation and the swing set, and half of the patio was done. We were subsequently in litigation with him last year when this action was started. At the beginning of the action, we informed the township that it was our advice, the advice of our counsel, that we need to leave everything as is during that litigation. We've subsequently settled that litigation with the contractor. He's agreed to pay us back the monies that were given us. But the representations that he made to us during that time were that everything that we were doing in the yard was in accordance with the permits and zoning with Howell Township. He obviously lied to us. In addition, he lied to several of our neighbors in projects that they were doing, and there's some criminal matters pending for that contractor.
Okay, now, was there an irrigation permit pulled for that?
I believe so, yes. And I've been to the town to check on those permits, so my answer to that is yes, unless I'm told otherwise. So yes, the answer is.
Okay. Matt?
That doesn't require a zoning permit or a land use permit.
Well,
I believe it's just a plumbing permit. So nobody's looking at the extent or where it's going.
No, I understand, but a plumbing permit, they have, by New Jersey, they have to supply a drawing for an irrigation system.
I'm not aware of that.
Whenever you
I'm
pull
not
the
aware of
permit.
what the plumbing department needs for that permit.
Okay.
Yeah.
Because they're supposed to, they're required to give gallons per minute, how many zones, all of that's part of the permitting, so.
Even if it is, the plumber's not looking at exactly where it's going in the yard
Okay.
and the other things that I would be checking if it were to come to me, but this doesn't.
Okay. My other probably my last question, were you aware that there are monuments placed, conservation easement monuments
Yes,
and
sir.
farmland buffer?
Yes, sir.
Okay. Okay, that's my extent of questioning. Does any of the board have any other questions?
May I
Yes, sir.
see, Chairman, may I see the copy of the letter from the DP?
Yes.
Thank you.
I'm gonna
Yeah,
let
could we
them,
review these real quick?
yes.
Yeah, because I just saw it.
Any other questions other than the letters? Okay, we're gonna pass it down. Do you have any more?
I think I might have one more. You can pass it.
Yeah, I'll pass that. Who's here for the cases?
Now, was that brought up any in the litigation as far as them, as far as the contractor putting this in conservation area? Was that brought up in any of the litigation?
We filed a lawsuit, but it ended up in a settlement, so we have a judgment that never went to trial. So there was no trial to bring anything up. I'd have to go back and look at the complaint to see if it was mentioned in there. It was mostly monetary damages that we were going after, because he had taken a large sum of money from us, and there were no materials or work to show for it.
Okay. Take a few moments, let the board review this letter.
Sure.
He wasn't here. What are they thinking? Chairman Shaw. What are they thinking of?
Go in there. There's some criteria that the ADA attorney needs to address first too. I think we want to put it on Huh?
Everybody down there is good?
Yeah.
Might have been to the wrong thing, or maybe he was here for the other case. I don't know. Is this enough, or do I have to say what litigation it is?
Okay. Any questions of this from the board as far as the letter from the DEP?
No.
Professionals? I want you to address the board, please. There's two issues here.
Yep.
One is conservation and one is farmland. I think the DEP addressed the conservation
Okay.
end of it. What's our ordinance of the farmland? What does it specifically say?
Hold on, let me pull it up. It says the buffer it should be 50 feet wide, a 4-season buffer, in which the buffer shall consist of at least two of the following. Landscaped fence or wall to at least 10 feet high, landscape berm of at least 6 feet high. And then it talks about the setbacks, like the building setback should be measured from the buffer line. But basically, we typically require a berm with a double row of evergreens to create that 4-season buffer between the farm and the residential use. And we don't allow any disturbance of that buffer at all.
It's natural growth, correct?
Correct. Once it's, I mean, obviously, once it's, the berm is put in and the landscaping is installed, then we don't allow any touching of it.
Now, was there any landscaping provided from Toll Brothers?
Looking at the plat, it does, I mean, I don't have the landscaping plan, it just, the plat that I have just shows the easement.
They're actively planning the landscaping. Our engineering department's been out inspecting it because they're still not off their bond, so they're doing that work currently.
Okay, so the farmland buffer is being planted now?
Yes, in some areas it might be done, some areas they're working on it.
Okay. Okay, any other questions? Are y'all familiar with that farmland? Okay, Mr. Tropley, would you like to address the board?
Well, before I do that, or before Chris and I do, I want to know from Mr. Leone, do you have any other witnesses this evening?
I don't.
I'm sorry?
I do not, no.
Okay, thank you. So you rest your case then, and
I'd like to reserve, to rebut any of the information that's being put out tonight.
Correct.
I've said what I need to say at the last meeting, but there's additional information we're discussing.
I agree,
Thank you.
I agree.
I would open it to the public then. If that's, we have no further witnesses, and if Mr. Leone is finished with his case, I realize there's no public here, but for the record, I think you should take notice of that.
Okay,
Can we clarify the ADA piece?
well, Mr. Saya had a question. Can we clarify the ADA portion of this?
Well, what I will do when the case is closed is I will give certain instructions to the board that may be supplemented by either Mr. Casouris or by our planner. But I have some framework that I think the board needs to consider, but let's get to that point first.
Okay, that answer? Yep. Okay, can I have a motion to open to public?
Make a motion to open to the public?
Motion by Mr. Moretti,
Second.
seconded by Mr. Mertens. All in favor?
Aye.
All opposed? Anyone in the audience wish to come forward, ask questions, or state a comment? Seeing none, can I have a motion to close?
Make a motion to close?
Motion by Mr. Moretti,
Second.
seconded by Mr. Mertens. All in favor?
Aye.
All opposed? Okay.
Mr. Chairman, members of the board, this application comes before the board essentially as a bulk variance in order to seek relief from the farmland buffer and from the conservation easement, and specifically, as I understand it, and again, just trying to put it on the record, there are three things to consider: whether or not first of all, the applicant has made his variance proofs with respect to the three items in the buffer and conservation easement, which would be the sprinkler system, the mowing in the area of the farmland buffer, as well as the playset in the buffer. The applicant also has, by way of proof, brought forward a request under the Americans with Disability Act, which, of course, Mr. Casouris at my right side here is been retained by the town to review. So you have to consider it as a dual application. Number one, has the applicant made his variance proofs? And if he didn't make his variance proofs, is there something else in the ADA which permits this board to grant him relief? So I'm going to give you some basic instructions as I understand it as you go forward with this application. So in the present case, this applicant's requesting what's known as a reasonable accommodation from the zoning board as a result of his disability. Now, the Americans with Disabilities Act does not, let's say, supplement or supplant or somehow overrule the zoning. It does not. But basically, you have to have certain considerations in mind when you look at it. It does not take the zoning law and then, for example, just vitiates it, throws it out the window. The question is whether or not the applicant has made certain proofs with respect to the ADA. Number one, for example, has the applicant in this case established a disability under Title II of the Americans with Disabilities Act? Well, for your record and reference, he did submit Exhibit A9, which speaks for itself with respect to a disability. So once you make that threshold, let's say, determination, then you have to consider that the act requires public entities to make a reasonable accommodation, and don't lose sight of the fact of the word reasonable. Reasonable accommodations of policies, practices, and procedures to avoid any kind of discrimination against disabled individuals. So the initial burden is on the applicant to demonstrate that the requested relief is necessary and related to the applicant's use, and as I see it, in this case, of his property. We're not dealing with access to a building or anything here, but it's basically access to the entire property and whether or not the requested relief is necessary and related to his use of property. So what do you consider when you're making these determinations? First thing, as I view, is are the accommodations that are requested, which is to keep everything where it is, reasonable for the board to grant? Well, in this case, we have an exhibit which the board now has marked, and Mr. Leone also has a copy of, I've got the wrong one, our last exhibit, which was number,
The last one?
B11.
thank you, B11, which basically states the DEP's position. Now, they say nothing about the ADA, but what they say is that you have no right essentially to go beyond the township's agreement, and they basically are leaving that up to the zoning board. And we know what the requirements were if the board were to grant relief. That is something that the board needs to consider. Whether right or wrong, it's there, their position is on the record, and they're essentially saying, you really can't grant that kind of relief, but I'll leave that to the board for your review. And then the second thing that you have to consider is, again, do these requests relate to the disability that has been testified to on the record? As I understand federal case law, and I'm not going to start citing cases here, but my understanding is that courts have shown that, or have held that a showing must be made by the applicant that the requested accommodations be essential, not just preferable. And the third thing, does the granting of the relief fundamentally alter the planning and zoning scheme? If the board was inclined not to grant relief, then the burden shifts to the board to demonstrate that the requested accommodations are not only unreasonable, but not necessary. And again, just in terms of the general principles of zoning, zoning law does apply here. The MLUL does apply. And you need to review each and every aspect of testimony placed on the record by the applicant, his burden, as to whether or not he's met his burden. And if he has not met his burden, then the board needs to make findings of facts based upon what I would call substantial credible evidence in the record. But remember, and again, this is just for the last time, and I'll defer to Mr. Kasouris if he has any further comments. Zoning laws are not preempted by the ADA, okay? But there's certain findings of facts that you have to engage in, pro or con. And with that, I will ask Mr. Kasouris if you have any further comments.
As the board is aware, I'm here on behalf of Howell Township. Is this on? Yes. All right. Here on behalf of Howell Township to give some information concerning the American Disabilities Act. I agree largely with Mr. Tropoli, with what he's advised the board. And what I would say is, let me say it another way, because there's really three things from the ADA's perspective to look at. Mr. Tropoli has advised the board with regard to the municipal land use law, and I'm not really going to get into that because that's not my role here. There have to be three essential findings by the board in order to decide whether or not there can be relief granted separate and aside from the municipal land use law under the ADA. So essentially, what the ADA would require, mind you, and you have to think about it a little backwards first, okay? The ADA requires the township, or requires a covered entity, whatever that covered entity might be. In this case, the zoning board. to make a reasonable modification in its policies or programs when those modifications are necessary to avoid discrimination on the basis of disability, unless making the modifications will fundamentally alter the nature of the program or the policy. So as the board that's considering this request that's being made under the ADA, it's incumbent upon you, when you make a decision tonight, to make some findings of fact. You need to make decisions and place them on the record pursuant to the ADA. So what do you need to decide? You need to decide first, are the modifications requested by the applicant reasonable? Why or why not? Second, are the required modifications necessary? Now that's a key word, necessary, to avoid discrimination on the basis of the applicant's disability. Why or why not? Now, in order to get through that second question, you need to make a decision as the board, and you're not doctors. Is this applicant disabled within the meaning of the ADA? Now, that burden is on the applicant to prove to the board. So what you need to decide is, does the applicant, has he satisfied you as members of the board that he suffers from an impairment that fundamentally affects a major life activity? Now, as I understand it, the applicant has said, I have difficulties with regard to breathing. I'm simplifying it, but it's breathing. I can assure you, breathing is a major life activity. You don't have to decide that. What you do need to decide is, in what way does this impairment affect the applicant's breathing? Does it substantially limit it? It's substantially limit. That is the key word there. So, we just talked about, are the modifications requested to the zoning scheme and the conservation scheme reasonable? Why or why not? Are the requested modifications necessary, key word, to avoid discrimination on the basis of the disability? Why or why not? Which requires you to make a finding with regard to disability. If the answer to those two questions are yes, then you need to decide, would granting these modifications fundamentally alter the nature of the program or the policy? Okay, so findings need to be found. Will this fundamentally alter? Does it change the nature and character of these programs? Does it change what these things are designed to do in such a way that it almost renders it meaningless? Now, if you find yes, then the argument is that this is not the type of modification or accommodation that should be granted, because the entire program is being changed. So that's what the board needs to consider. And I know it's challenging and new. Nobody told you that you were going to have to come to a zoning board meeting and sit down and be nurses and doctors and figure this stuff out. And hey, wait a second, people always told me we're the zoning board and we have ordinances in place and we're bound by them. How is this possible that it has to give way to something else? It's new for the board, but that's why I'm here on behalf of the township, to give the township's perspective on that. So if there's other questions, if there's other guidance that the board feels it needs, I'll do my best to inform the board of the position of the town. If you think that I've laid out the basics and Mr. Tropoli doesn't disagree with me, remember, he's the attorney for the board. I can give the town's position, but you're the board. So if I can help, let me know.
Jim, do you have anything to add?
No, I mean, I think that the attorneys have laid out, the parameters of the purview very well. I do think you need to take it back at some point to our ordinance, in that every major subdivision requires the perimeter buffer, and we've been very consistently applying that. In this particular instance, you're dealing with a farmland buffer, but on top of that, it was placed into a conservation easement, which now puts this property in the jurisdiction of the DEP. We've gotten the correspondence from the DEP that are unsupportive of the relief, with the exception of the mowing. And other than that, I think ultimately you need to decide whether the applicant has met his burden under the MLUL with respect to the variance. You know, this is not a hardship variance. This is a C2 flexible variance where goals of zoning need to be promoted and the positive and negative criteria have to be met. So you need to decide whether or not the applicant has provided enough information that would justify leaving the irrigation system in place and the swing set in place in our farmland buffer, perimeter buffer, conservation easement.
Charles?
Just reiterate kind of what Jen said. DEP, obviously, they made their position clear on the disturbances and structures within the conservation easement. The township ordinance is also clear structures. It doesn't differentiate between on, above, below. Any structure within, cannot be within there. There were some questions on locations of it. Just to rehash for the board, if the structure were to be moved, it would be, to get it outside of the easement, we're talking about 29 feet from the back of the mulch area to be outside of the conservation easement. Again, I don't know the location of the sprinkler system or anything like that, but I don't think that it would be difficult for an irrigation contractor to remove the last line or to cut and cap it and replace rotors or anything like that, should it ever go to that route. But like I said, the ordinance is clear, no structures on, above, or below a conservation easement.
Okay, did you have any rebuttal?
So, a lot was just said, and I'd like to address a few points. With respect to the letter that you all read, there's a few inaccuracies in there that I'd like to point out, and we can get clarification. I don't think anybody mentioned them. And I believe the town engineer just mentioned this, so I'll go backwards. The letter provides that the irrigation system is in violation of DEP standards. I'd like to point out to this board that the state standard for construction is on or above ground, not below. There's a differentiation between the town definition, the Howell Code, which does define structure as on, below, or above ground. But the state definition of structure is on or above. I did read what the director said from the DEP, but I believe that she was mistaken. The other point that I'll bring up, and so with respect to that point, if in fact the sprinkler system, irrigation system is not in violation of DEP law or the DEP standards that they follow, then to use the DEP as a defense for that position is inaccurate as well. So it just follows down. In other words, if the DEP has no standing to enforce that because their statute doesn't allow for structure, doesn't prohibit structures below the ground on conservation land, then we really just fall back into the Howell standards, which I agree. The second thing, which was a little bit interesting to me, and I'm not sure if the purpose of putting it this way was to coerce me to settle or some type of penalty. In the second paragraph on the second bullet on the second page, the director says that the compensation for allowing this easement is a minimum after the fact compensation ratio of 20-1. First of all, the space that we're talking about here for the swing set is a space that's 20 by 25 feet. So we're talking about 600 square feet of, which is equivalent to 1% of an acre. Okay, so in deciding whether or not my request is reasonable, I just want to point out I'm asking for the town to allow me to use 1% of an acre in my yard to accommodate my disabilities. And so for her to say that the minimum compensation ratio is 20-1 is just not true. Their website states that the maximum is 20-1. And that's only used for penalty purposes. There's plenty of open source material where applications have been filed by this town and by the county applying for diversions of these types of easements. It happens all the time. Those standards that apply in those requests are land replacement of 4-to-1. So remember, I'm asking for 1% of an acre, so a land replacement would be 4% of an acre to replace that, and a 10-to-1, or a 10-to-1 land value here. Again, 1% of an acre in Howell, or 10% replacement. The state in NJAC 7:36-26 also describes what I'm asking for here because it's less than 1/10 of an acre. It describes it as it says, under this section, the code and accommodation the requesting is considered a minor disposal of parkland subject to compensation of $2,500 for the first 1/10 of an acre and $1,000 for each additional 1/10 of an acre up to 1 acre. If the entire easement were diverted, and I'm not asking for that, I'm asking for 1% of the acre that I live on to be used for my swing set. But if the entire 50-foot by 160-foot easement were diverted, the total cost under this standard would be $3,500. I'd like to point out to the board that I've spent over that in coming today before you. I've spent over $4,000 between engineering reports and application fees. And so to say that $3,500 is unreasonable to grant my request when I've done more than that to ask for it is probably something you should consider. Those are the 2 points of the letter. The last thing related to the letter, which I'd like to point out, and I believe the 2 attorneys here disagreed on this point, although it wasn't very obvious, and I believe I agree with Mr. Katsouris, Attorney Katsouris, and not Attorney Tropoli, but they can clarify. Attorney Tropoli said that the zoning standards do apply. There's a lot of cases on this, but Innovative Health Systems versus City of White Plains, and I'll just quote from the opinion, it is by now well settled that the federal courts may exercise jurisdiction in zoning matters when local zoning decisions infringe on national interests protected by a statute or the Constitution. Because federal law authorizes a claim, provides a remedy for discrimination against individuals with disabilities in zoning activities, and extends express power to the courts to modify discriminatory practices. The argument that a zoning dispute is more properly relegated to a local regulatory or administrative procedure is simply not correct. Now, maybe I misunderstand Mr. Tropoli's position here, but it's my position that there's federal law that preempts both the state DEP and their position and my position and the Howell Code. And that federal law is given to you to make a decision on. And so to the extent the letter, and we're still talking about this letter, to the extent the letter imposes some type of penalty and does not address my request, they're in violation of the law. And it's within my right to sue the state if they acted upon me. However, and this is interesting, they've not responded to 3 official requests for an accommodation that I've sent them in writing. They've not responded. So they've responded to the town, but not to me. I think the reason for that is that there's a somewhat of a legal loophole in that if they're not taking away my right, I really can't sue them for taking away my right. And so I don't know that this is the case. I'm just assuming that there's a reason why they're not responding to me. But to the extent this board denies my request today, and the DEP denies my request, my remedy is to go to court. I chose to come to this board because I thought this was the least friction for the town. I'm not here to waste my resources or the town's. Quite frankly, this has been over a year and I'm really tired of this. I'd like to be done with this. So to the extent we can settle this today, that'd be great. The statute that allows me to sue the town or the state provides for attorney's fees. So there's no shortage of attorneys that are willing to take this case. And the attorney that I did reach out to just won an $11 million.
Okay, I don't want to, we don't need to go there.
Well, someone had asked last time about litigation, so I just wanted to point that out.
Well, that's fine. We're not here to discuss litigation. Okay. Any further, Mr. Tropoli?
I have a couple things, but I just want to make sure that Mr. Leone's finished with his...
I'll concede that I have not met the standards of Medici. So we don't even have to make those, we don't even have to have that discussion here. The
the 10 elements of the zoning law in the state of New Jersey is preempted by federal law, and so this accommodation request, in my opinion, falls on what the attorneys had mentioned. I'm finished, thank you.
Okay, so I just want to correct a couple things.
Sure.
First and foremost, you absolutely need a diversion for below-grade utilities. I'm actually in the process of dealing with it in another municipality where an extension of sewer across property below grade requires a diversion from the DEP, and it's a process by which the township is undertaking currently. So to say that below grade utilities do not require a diversion is an untrue fact.
Okay.
Secondly, when the DEP Green Acres program looks at a diversion, they don't take the square footage of the disturbance. It would be the easement in its entirety, because once there is disturbance, the DEP feels that the conservation easement is no longer providing the value with which it was intended when it was dedicated. So the entire area of the easement would be considered for the diversion, and while once upon a time the diversion was 4-to-1, those days are long over. So I've been dealing with this issue for the 25 years of my career, and I feel safe in saying that when the director of Green Acres tells you it's a 20-to-1 diversion, you can bet that that's what they're going to be expecting. So I just wanted to correct that for the record. And with respect to the legalities and the litigation, that's not my area of expertise, and again, that's kind of outside the jurisdiction of our purview here tonight. So I just wanted to make those corrections.
May I respond to that very briefly, Mr. Chairman?
Yes.
This is not a request for a diversion. We are asking for a request for an accommodation for a disability that I have for breathing. It is very serious. I have shortness of breath on a daily basis. I'm on medication. I can't go outside and barbecue in my own backyard at certain points of the year because of the pollen that's in the air and the fear of dying. There are millions of Americans that suffer from this disability. I'm not here asking for variance requests. I'm not here asking for a diversion. I'm asking you to make a reasonable accommodation so that I can spend time with my children in my backyard. I've spent over $4,000 in a year of my life asking for this when I did not have to. I could have went straight to court. I give you the courtesy of making this decision. It was said last time that you're a very patriotic board. When 9/11 happened, it took me 1 month to join the military. I didn't ask for this. I didn't ask for this asthma, for this disease. I went to Iraq. I served my country. I came back, and I have a disease, and I can't breathe. And so I'm happy to trade it with anyone in this room and move the swing set if that's what you want me to do. Thank you. I have no further statements.
Hey, Matt? Is the conservation easement / farmland buffer deeded to Mr. Leone?
No, it's an easement that's dedicated to the township.
I have the deed here.
The buffer, you say that the bond has not been released. Is Toll Brothers, are they still gonna go behind into this easement / conservation?
They're still doing work in the development. I don't know what portion of the development they're working in.
Is the swing set in their way?
It could be, I don't know.
We need to know.
Okay. Okay, Mr. Tropley?
Nothing further.
Okay,
I have a question.
yes.
Yeah, Mr. Leone, one thing that we touched on briefly at the last meeting, you had mentioned the swing set is not going to be there permanently. It's more, and you said about 2 years?
My children are 4 and 5 years old.
Okay.
At some point, they're not going to swing on that swing set, and we're going to take it down. My property is very well maintained, and that's really what started this issue, is we
Okay.
cut the grass, we cut the weeds, and so this is not the type of situation where I'm going to leave that there for 20 years, no.
Okay, so once you take it down, then you're just going to let it pretty well be,
Grass.
okay. Now, that's it, at that time, do you think this is going to be an issue with your asthma, not having the playset there?
The issue is that I cannot put the playset in any other location that's
Okay.
suitable, and so to the extent we're removing the playset, there's not an issue. Because I don't need another, there's no more playset to be positioned
Okay.
in the buffer. So yes, thank you for those questions.
Okay.
Okay, any further? What's the pleasure of the board?
Mr. Tropley, before I I'm conflicted here. I'm going on the record and saying, and you know, I know this is public, so, you know, my mother, when she was a young girl, went out and worked in York on her uncle's farm. She acquired leiomyosarcoma, only 3 cases in this whole country at the time that happened. I can't stomach knowing that young children are in a farmland buffer when pesticides and other things are being used in the farming activity, because it's not healthy for the children. So in my mind, that swing set has to come out. Not only because of the life, safety, and health of the children, but to also not violate the conservation easement or farmland buffer in accordance with our ordinances. We have not had anything other applicant like this, so it's a little difficult to conceive what's on the record, what's precedent, etc. As far as the applicant being disabled, I'm with him 100%. Absolutely. And there's no denying it. I don't know how the swing set actually helps the applicant in meeting that criteria. So that brings us to the last 2 under the ADA. Are the mods reasonable, and are they necessary? Well, is it the irrigation system that's necessary or not? Is the irrigation system a benefit to the applicant or not? I can't make that assessment because I just don't know. I would welcome many of my board members here that's been hearing this case to give me some comment, so to help me move forward one way or the other.
Well, Mr. Saya, I would concur that the irrigation is necessary for the grass to benefit the best in that situation. As far as if you have a drought, you're going to have more weeds and you could have more, issues with allergies. That's the, in that standpoint, that's my answer to yours.
The question is it allergies, the disability?
I'm not a doctor, so I can't.
Mr. Chair, I might be able to, so to answer your question, Mr. Saya, I do think that the ability to water the area is important for the asthma issues. However, the question that you need to answer is, does the irrigation system have to be exactly where it is? Or as Charlie had indicated the last time, can it be relocated outside the easement and still directed into the easement, which would not violate our ordinances and be consistent with the DEP? That's the question that you have to reconcile.
But, Jen, it's still, both ways it's going to violate the ordinance.
Well,
Because
correct.
if you're mowing the grass.
Correct. That's still a variance that the
that's a
applicant is
variance.
asking for. Correct. So
Exactly.
there's 3 components here. So can the swing set be relocated? And I think Charlie went over that at the last meeting, that there's significant room between the back of the house and the easement. It may not be the most convenient location, but there is area to relocate the swing set. Secondly, can the sprinkler system be relocated so that it still irrigates the area in question but doesn't violate our ordinance? So those are the first 2 things, and that's really what the DEP focused on because those are what they considered structures. The third piece of it, which comes back to you as well, is are you willing to allow the applicant to continue to maintain the grassed area in the easement as he's been doing up till now because of the fact that he has an ADA issue? So there's 3 prongs that you need to make a decision on. If both the swing set and the irrigation are moved out of the easement, then you're really just, the variance would really just be to allow the applicant to continue to maintain the buffer, because we do not allow any disturbance in the buffer per our ordinance. And that's not a state issue. They have indicated very clearly in their letter that that's not on them. They're perfectly fine allowing the mowing. That's on us. So that's the third prong of it that you have to make a decision on.
I have a question. I don't, as a new member to the board, I'm struggling with, did Mr. Leone's disability come about or occur because of his service to our country? Did he contract the asthma because of his service to our country? And as a resident, as a fellow resident of Howell, New Jersey, shouldn't we be proud of our men and women who have served our country and provide the benefit of the doubt, I guess? And I don't know if that's part of the consideration or not. It's just going through my mind.
Mr. Tropoli.
Mr. Cantor, the way that I would answer that is that the applicant has submitted his medical records from the Department of Veterans Affairs for the board's consideration. And I'd leave it at that. I don't think there's a question regarding that. But whether or not that trumps anything else, you still have case law, you still have the variance relief, and you still have the DEP's position and the township's position respectfully on the farmland buffer and on the conservation easement. That's what the board needs to focus in on. It's not a question of whether or not he has submitted medical records that shows he's disabled.
No, I'm not questioning that,
Right.
how the disability impacts our decision.
There
is no answer.
Well, the answer is that he's come before this board, as he is required to, quite frankly, when you seek variance relief, and has submitted documentation which says he's disabled. It's that simple. Well, it's not simple, but I mean, it's that uncomplicated.
Mr. Moretti.
Like everybody else here, I'm a little confused. Mr. Leone wants to maintain his property in order to alleviate the pain of his allergies. What about his neighbors to the left and to the right? What are they doing? Are they maintaining their property the same way Mr. Leone is? If they are,
It's my understanding that there were letters that went out from the township to a variety of residents that had structures or whatnot in the easement, reminding them that the easement exists in the rear of their property and they are not to have any structures, they are not to touch it, they are to stay away from it. And it's on my understanding that every other neighbor either removed the impediments or stopped maintaining the easement so that there's no more violation with the easement, the farmland buffer, or what have you.
so with that said, those buffers to his left and to his right are natural,
Correct,
which is growing whatever.
right.
So now the wind doesn't just funnel itself away from Mr. Leone's property, if I understand Mother Nature. So all that stuff is blowing onto his property anyway, so no matter what he does with his area, he's still going to be affected by the surrounding neighbors. I mean, we can give him as much accommodations that are reasonable under ADA, but the neighbors are the neighbors, and he's going to be affected by those particular allergy properties. And if I remember correctly, Mrs. Leone mentioned about the swing set. She likes the swing set where it's at because she can watch her children. Has nothing to do with the ADA of her husband, but it's to watch her children.
May I just advise the board on this point? The ADA, the goal of the ADA is to have individuals with disabilities receive treatment equal to those whom are similarly situated, okay? So the neighbors, it's interesting the board brings up the neighbors, because the goal is to treat them similar to the neighbors, not give preferential treatment, that's a mistake in reviewing the ADA that folks think about. Folks think that the ADA requires preferential treatment. It doesn't. It requires equal treatment with regard to situations. Additionally, the ADA does not require the best possible accommodation to be given to an applicant. What it requires is reasonable accommodation with regard to the situation. There is nothing in the law that would require an all or nothing approach from the board, or an anything approach from the board, if there were other alternatives. It's not the best possible accommodation. It's a reasonable accommodation that would place the person with a disability in a situation similar to the others, to other folks who were situated in similar housing, so to speak. So I don't know if that helps the board or not. If the ordinance or the rule is vague and equally applied, then the burden really is on the disabled person to show why that rule applying to him equally is going to place him in a position worse off than those who do not suffer from the disabling condition. The other thing I do want to note is the applicant speaks to his asthmatic condition as opposed to allergy. So I'd ask the board to, we don't know what the medical conditions of the neighbors are, but whether or not that's relevant or not is for the board to decide.
May I respond to?
Mr. Tropoli? Hey, I'm gonna let Mr. Tropoli step in legally.
Yes, let him respond. Yeah.
Okay, go right ahead.
Mr. Moretti, at the last hearing, my neighbors were here, and they were prepared to testify that they've continued to cut the grass in their easements. So while I agree that the township sent out letters advising them that they should stop, it is also, to the best of my knowledge, and again, I can't testify for them, but my understanding is the township said that they can continue to cut the grass as long as they don't locate structures in the easement. And so that was a concession that was given verbally. I don't have any proof of that, except that if anyone cares to stop by, you can see the beautifully manicured grass across all properties.
For the most part, all enforcement actions in this area have ceased pending the result of this case to some degree.
Right.
Not that any one decision here will govern the whole town going forward, because that's not how the variance works. But we haven't performed any inspections in the area recently. We cleared violations 9-12 months ago, and we really haven't been back. So, I mean, last time your comments were taken as something we should follow up on, and you took exception to that. So are your comments tonight a request that we follow up with your neighbors some more?
No, sir, that's not
Okay.
my comment today. Mr. Moretti asked a question about my neighbor's property. I was answering that question.
I
just
just
clarifying
want to
myself.
ask you one more question. If I'm just running it through my mind right now. There are certain weeds and trees and so forth. So you make sure you don't put any of that grass or weeds or anything on your property.
Yes, sir.
So your neighbors are doing the same thing. So they're weeding out all the weeds that you're allergic to. They're planting all the grass that you're not allergic to. Is that what you're saying?
My neighbors are maintaining their property and weeding and putting whatever they need to put on to maintain the weeds. I don't know what type of grass they use, but it was my statement from the last hearing that when I approach certain areas of my neighbors' yards, I do get a reaction to that. So there are certain areas that I can't go to in my backyard during certain times of the year. And so to answer your question, I don't control theirs, but at the same time, I know where I can walk in my yard, and that's what I'm asking for.
So that's what I'm referring to, is the fact that you can't control your neighbors' backyards because, as you say, there are certain times of the year that you walk out in the back and you can't be back there. So there's things on their properties or on that farm
Correct.
that are coming across
Yes.
and doing this to you.
Yes.
So by you putting the irrigation in, leaving the swing set in, and maintaining your property 100% your way, how are you going to accommodate the farmers' pesticides, as Mr. Sayer said, coming across, affecting your children, affecting you? and also the weeds and so forth coming from your neighbor's yards, coming across onto your property during those times when you can't be out there.
Sir, I agree with you. I deal with my disease and where I can't go outside at certain times during the summertime. And that's absolutely right. And that's what I have to suffer through. Unfortunately, there's no accommodation request that I can ask which would make the farmer do things.
Can I ask a question? Can I ask a question? I'm not an attorney.
stop.
No, I just have a simple question. Just as a normal person, as a normal citizen, as a person that graduated Howell High School, does it help at all if we took responsibility and paid out of our own pocket to plant some sort of extra shrubbery to maintain, like to keep that happy balance between the farmland and our property?
No,
Okay.
ma'am, you're not allowed to do that.
Oh, okay, it's a
They-
question. All
That's
right.
what earlier discussions were
If it's
taking
on-
place. Toll Brothers is in the process.
Oh, I
of-
thought you meant I wasn't allowed to ask the question. I'm like, okay,
No,
sorry.
no.
You said you are not
No,
allowed to do
no,
that, so.
No, you're not allowed
To plant
to
anything
plant
there.
in that farmland buffer.
Okay, so if I can
But at the back
ask
of the
something, so
property.
after.
On your
Toll-
property, you can do what you want.
But so
you
then
know.
if we're truly concerned, first of all, again, I'm not an attorney and I'm not pretending to be, but my kids are gonna be running around. They're 4 and 5, and I'm sure you guys all have kids or grandkids. There's no like, oh, we'll take the swing set down and keep them from that area. They just run amok everywhere. And I know you brought up that I said I can see my kids. Yes, I am a mom of 2 babies, 4 and 5. That is one thing that I like. It is not why we're here today. So I don't
Right.
want that to be used against me, number one. I said 3 things this whole hearing, and I don't want that to be thrown back at me, number one. Number 2, does it make sense? Does it make sense that after Toll is done planting, whatever they plant, we're happy to have them planting, that we add additional shrubbery or greenery there to create more of a buffer?
On your property, you're allowed to, but not in the farmland buffer or
But
the
if their
easement.
properties, or if the buffer's here and our property's here, fine, we'll plant it on our property, but
That-
it would
that
still be a
you're-
wall of shrubbery.
You can put up to a 10-foot high fence back there.
But then
If
wouldn't
you-
that satisfy people's concerns of having us receive some of the pesticides and?
But then you would not be able to mow that buffer, you would not be able to water that buffer, and your kids would not be able to play in that buffer.
Even if just in that
If you
certain
put
area.
if you put a
Okay, sorry.
fence up, if you put a wall up on your property, you're taking it away from the buffer. You're taking the buffer out of your backyard.
That's what the farmland buffer, now I'm gonna speak. The farmland buffer was created not for you. It was created to protect the farmer from a development. The farmland buffer. The conservation easement, you fall into a category that's normally not the issue. There's normally not a conservation easement and a farmland buffer. There's usually one or the other. But you just so happen to be in an area to where it's a conservation easement, and then there's also a farm behind there, which is also a farmland buffer. We have so many conservation easements within Howell Township. Granting relief, it's very hard to do that in a conservation easement. Number one, the township, this board really doesn't have jurisdiction on granting a variance for a conservation easement because it is directed by the DEP. You know, it's really not our jurisdiction. What brings it to this board is that farmland buffer. And, you know, it is very, very hard to grant relief in a farmland buffer. I'm a farmer. I deal with it all the time, with the developments. And, you know, I got a hayfield that's right next to houses over off of Ford Road. I get complaints all the time because dust whenever I'm baling hay. You know, I've actually had the cops out there once. You know, you can't do that. I said, I can't do this? well, the dust is blowing over there. You know, they're complaining that they can't keep their windows open. Look, that's what that farmland buffer is designed to keep from happening. But getting back to the case, we need to come to a decision based on what our professionals have advised us. Both attorneys have advised us. That's where we need to be. Now, what is the detriment to granting a relief? You know, you say each case stands on its own. You know, it's a site-specific or a case-specific decision. But setting a precedence, not based on ADA or any of that, let's leave that to the second part of our decision. But whenever you break the farmland buffer, you're setting a precedent that, well, he's doing it, why can't we do that? As many acres of farmland buffer that we have around developments, it's gonna be a logistical nightmare. I mean, you know, any and everybody. That's why I have never, in the years I've sat on the board, granted relief to a farmland buffer, except one case.
And you voted no.
And that was Adelphia Farmingdale Road was in between the property and the farmland. You had a whole 75 to 100 feet?
Yeah.
Then they had to apply, according to the ordinance, they had to apply a 50-foot buffer. You have Lakewood Farmingdale Road in between. That is the only one that I ever bent backwards and said, you know, you got Lakewood Farmingdale and now you want another 50-foot buffer? It didn't make sense. But in the developments, that's why I asked the questions in the beginning. I needed to kind of set a timeline. You had a contractor. If he would have gone down, if he knew what the ordinances were, he would have never touched that in a million years, because we deal with that with the swimming pools. The same thing. The contractors don't know the ordinances. They get the permits and then they sell a bit of good. Well, you can get, you know, we're going to have a concrete truck here. You know, let's take it out another 5 feet here. Well, the ordinances, there's setbacks to that. And if we grant one, and trust me, I've been on the board long enough, we have had swimming pool case after swimming pool case here. There's been a very few that we've given relief to. Most of the time, they will give the relief if they can demonstrate that there's no water runnage. You know, that's given relief. We had 2 in the farmland buffer. They both went down. They had to move their concrete. They had to take the concrete out. But we start breaking our ordinance on setbacks. It's a never-ending thing for us. You know, it will just start snowballing right on down, because there is so many developments, new developments coming into the township, not only ones that are already built, but it's gonna create a nightmare. And I mean, you know, whenever you start, you can't stop it. That's why they're put into place, those ordinances. And I'm only addressing the farmland buffer. That's all I'm addressing. And so, you know, now that's my spiel, in my opinion, on the farmland buffer. And, you know, I don't know if that confused people more or not, but just, I'm gonna ask the board, what's their pleasure in this case?
Sir, before the board votes, and this is for the interest of not going to court on this, if we can ask the attorneys a question, it's my understanding that your rationale there is not a reason not to deny my request. And so to the extent you vote based on that rationale, I mean, the courts are just going to throw this out.
Okay.
You can ask
Well,
them before we vote.
There's other findings of fact that's, that's,
Okay.
that will come out, so.
That's fine.
So I'm gonna ask the pleasure of the board.
Well, before we vote, I just have one question
Yes,
for
sir.
Mr. Mr. Tropley, there seems to be, in this case, three separate parts of this request. One's the mowing, one's the irrigation, and one is the swing set. When we make a motion or our decision, do we have to vote one or all of them, or how do we go about if there's some that we feel is appropriate?
I think you can take into account what the DEP said. You can take into account what the applicant said, as well as his disability. I think you can bifurcate it if you wanted. You can approve, you can deny, you can approve some, deny some. It depends. In other words, you've heard Chris and I put the rationale on the record as to what the findings of facts have to be. If you're denying something, you have to put the reasons on as to why you're denying it, just as well as you are if you're approving something, bearing in mind all of the evidence, including the evidence that the board presented, which would be the DEP letter. But yes, you can separate it,
Okay.
in my opinion. Would you agree with that, Chris?
I do.
Thank you.
All right, we're all going to sit here and we're not going to do anything, right? So bifurcating is what I'm thinking. All right, I'd like to put it on, a motion on the record, that the swing set is coming out of the conservation easement. I'd like to also encourage the applicant, and I don't know how this can be done, to go ahead and follow up and seek remedy with the contractor that move that irrigation system into that conservation easement, get it back to the property line and point it in the right direction, allowing the applicant to go ahead and still water the conservation easement. I'd like for the applicant to be able to go ahead and still mow the conservation easement until such time Toll Brothers comes through and finishes up with their buffer and so forth. And then at that time, the applicant can make a determination whether or not evergreens along the back of the property and on the side is a better solution than trying to deal with the farmland buffer and taking care of it. So how do we make that all in a resolution?
So if I can just clarify, point one, you want the swing set moved out of the conservation easement into the balance of the yard.
Correct.
Point two, you want the irrigation moved out of the easement. You'd encourage the applicant to have the contractor do it, but you want the irrigation out of the easement. It still can water into the easement, but the structure itself needs to be removed. And that you would allow the applicant to continue to mow in the conservation easement. So if I understand that correctly, your motion is to deny the relief for the swing set and the irrigation system, but to approve the variance to allow mowing in the easement.
That's
That's what he said. You may not agree with it, but that's what he said.
my motion.
Okay.
Okay, but what about until the point that Toll Brothers completes their conservation easement, their planting?
I don't think so either.
Toll Brothers is going to come through. They got to complete.
You're dealing with a different story there because Toll Brothers has bond money
Right.
put up for that conservation easement. Until it's planted, they're not gonna get their money back.
We don't even know what it's going to look like, do
Well,
we?
it'll be a berm with a double row of evergreens on there at a minimum, if not some other plantings.
That's what I'm saying.
And
which
if
was
that-
approved
if
as
that-
part of the
And
subdivision.
if that's not there now,
It will have to be installed, correct?
yes.
Will that be will that be between their property
It's in the
In the
farmland
easement.
buffer.
It's in the easement,
It's in the easement,
yes.
Yes.
okay? And that is part of the plan, is that correct?
That is part of the approved subdivision, which requires that farmland buffer. So we have that requirement with the berm and the double row of evergreens. As part of Toll Brothers subdivision that was approved previously, that's not this application.
Right, but no, so I just want to get
Yeah.
that clear. Okay.
And Mr. Saya, just so that we're clear, and again, I agree with Jen, when you say mowing the easement, you mean mowing the areas that are already grassed,
Until such time,
right? And not expanding that, is what you're saying?
correct.
Yeah,
And
I'm just trying to clarify the motion, Mr. Chairman.
well, under the
I-
ADA,
Right.
you know, we're talking about, you know, the ability to breathe, all right? And the fact that the applicant contributes to the fact that he's watering and keeping it grass, getting rid of the weeds, getting rid of as much pollen as possible in the back, is beneficial to his health, life safety and health here. So, you know, I'm okay with it until such time that Toll Brothers finishes up with that berm and those evergreens.
I understand that.
What do you want to see happen?
And then the applicant will vacate the easement.
Yep.
They'll stop mowing at.
Correct. Correct.
But Jim,
Yeah,
we're talking a variance.
that's what I said.
That goes with the property.
But the variance can have a condition associated with it.
Okay, now you just answered it.
Yeah.
Okay, so the variance would be granted, or the motion. The motion is that the applicant can continue to mow. All the structures have to be removed.
Correct.
Number one. But the applicant continue to water, he could have it reversed over in watering until the condition is, once Toll Brothers completes the
Their work.
easement plantings,
Correct.
then they have to vacate that, correct?
That's
Yeah.
my understanding of what Mr. Saya's motion was.
Correct.
Okay.
Okay,
And Matt, you're going to follow up, make sure Toll Brothers gets on it as best possible.
Well, they want their bond back.
yeah. So, okay.
I second that. The suggestion that Mr. Sayer has made is, I believe, is a reasonable expectation for the ADA by moving the sprinklers off the property and keeping the pardon me? Off the easement, I'm sorry, off the easement, while keeping that from drying out, as Mr. Martins has mentioned, that will cause more discomfort to our
A veteran.
veteran. I'm a veteran too, but he deserves a lot of respect for what he has done. And we have to take care of him the best we can, and I think what we're doing right now by Mr. Sayers' recommendations, I think it meets a meeting ground, a halfway anyway. Maybe not 100%, as Mr. Leone would like, but then we also, as I had mentioned earlier, he's got neighbors on the left of him, neighbors on the right of him, he's got the farmer over there, so we have a lot of different issues. But I second Mr. Sayers' motion.
Okay. Can we have a roll call, please?
Mr. Mertens?
I'm going to, before I vote, just make a couple quick points. Normally, I would say it's not a big deal to me whether if the playset stays or not, but the problem here is I'm not 100% sure if we leave it, we take it away, it's going to add more discomfort to you. That's the only thing I'm not sure, and my issue is we have to look down the road what approving the swing set to stay there is going to respond to other people down the road having the same. I know you have a health issue, and that may be a different avenue on itself, but I don't have enough, facts that this, moving the swing set is going to be detrimental more to your health. I also agree that the area should be allowed to be mowed till the work is done on the conservation, and I I'm in the landscaping business, and I know irrigation lines, you can cut them right at the property line. You put two heads, and those heads are going to water your lawn area, and I think that's what we need to do something for you, and I think in that regard, I'm going to agree with the motions that were put on. So yes, to, no to the swing set, and as far as the irrigation, to remove it, but water the lawn, and then you can maintain the lawn. So, yes to the motion.
Thank you. Mr. Moretti?
Yes.
Thank you. Mr. Saya?
Yes.
Mr. Cantor?
Yes.
Chairman Nansen?
No. And
Motion carries.
my no, let me clarify my
Sorry.
no. Number one, I think the modification is detrimental to our zoning plan. Totally. The issue of a farmland buffer, I'm not going to vote yes for something that's going to disturb a farmland buffer. That's second. Has nothing to do, my vote has nothing to do with the ADA, has nothing to do with that. It just busting our zoning. I feel that if our town council wants to grant relief for a farmland buffer, then that's up to the council. I don't think this board has that jurisdiction to grant relief to a farmland buffer. And that's just how I feel. Okay?
Motion carries.
Okay. Good luck, sir. Do you understand what was voted?
I do.
Okay.
I do.
All right, motion to go into executive session?
Yes.
We need to close out, or are we going to close out there?
We'll close out inside.
I just have to read the resolution.
Okay.
Ready?
Yes, hold on.
Yes, sir.
Executive session resolution, whereas Title 10, Chapter 4, Section 13 of the New Jersey Revised Statutes requires that the public shall not be excluded from any meetings of a public body unless a resolution authorizing such exclusion is adopted at a public meeting. And whereas the Zoning Board of Adjustment of the Township of Howell has determined that such a closed meeting is required to discuss certain matters which are exempted from consideration with the public in attendance under New Jersey Revised Statutes 10:4-12, namely litigation. Now therefore be it resolved by the Zoning Board of Adjustment of the Township of Howell that the public shall be excluded from the next portion of this meeting, and that the Zoning Board of Adjustment will not reconvene in public session thereafter. Be it further resolved that minutes will be kept of the meeting in closed session, and the time and circumstances under which that discussion conducted in closed session can be disclosed to the public cannot be determined at this time.
Okay, we've got a motion to go into executive. Do I have a second?
Second.
Seconded by Mr. Cantor. All in favor?
Aye.
All opposed?